number of legislation in the context also of the Commercial Courts Act, where we've had many discussions on pre-litigation mediation. Also of interest is the Mediation Council that has come to be as a creature here. Contrast that to the Arbitration Act, where there was a pushback on any sort of arbitration council that sought to regulate arbitrators or the process of appointment of arbitrators. So it's in this context, we will have a chat really, and we hope to take 30 minutes to get comments from Chitra, Ekta, and sort of have a discussion on what we think are key points. We'll then open it up to questions. Feel free to type in your questions. We have a large number of attendees from the mediation community, so thank you for joining us. But we also have folks who are students, people from the commercial world to see what they can do to write in. Chitra's caught in heavy rains, but she's still logged in from her car, so hopefully we won't lose her during the course of the webinar. So what I'll do is, Chitra and Ekta, if I can take 5 minutes of yours to please give us some thoughts on the bill, as it were. And I know that both of you were also involved in, giving your comments to the Parliamentary Standing Committee. You were involved in giving your comments on many versions of the draft. So if you could just give 5 minutes each on the actual bill, as it were. And just for some additional context, Chitra has also authored a book on mediation and policy. So she comes with that additional research background, and she's also a founder of the FCDR, which is the Foundation for Comprehensive Dispute Resolution based in Chennai. So Chitra, I'll start with you. Some opening thoughts and comments about the bill. Thank you.
Thank you, Purnima, and thank you to Sambad for organizing this, because I think the more we talk about it, the better understanding we'll have. My initial thoughts, the need for a law on mediation was on several grounds, which I think still are valid. The first is, of course, that there is the Singapore Convention, which provides a comprehensive way or comprehensive sort of policy on which international commercial mediated settlement agreements enforced by countries. So this, in fact, allows for, like the New York Convention does for arbitration, for an easier way of enforcing mediated settlement agreements, and is a policy framework that understands and articulates, what are the concerns in a mediated settlement agreement and how one needs to enforce it. So we needed to have a policy in place when we ratified it in order to implement the convention. The second reason why we needed a bill is so that we have even and sort of clear grounds that safeguard the rights of parties who participate in the mediation, the rights in the process, because we have splintered legislations in India, splintered policies that each talk, that each mold the mediation process in the way that they want. So, for instance, you have the Legal Services Authorities Act, where there is no, the guardrails of the Evidence Act are not available, but you have persons who sit as mediators or third-party neutrals who will listen to parties in an attempt to settle the dispute, but if it doesn't get settled, then they decide the dispute. This is the permanent local adalat. You have the MSME Act, which has the same body mediating and then deciding the dispute. So there is a need for us to set standards on how mediations are conducted, and secondly, what the rights of parties are. The third is that you have something on mediation, which is quote annexed mediation. You have the Arbitration Conciliation Act. Part 3 speaks of conciliation. But there is a lack of clarity on whether both are the same, and that if you had a settlement agreement through conciliation, would you be able to challenge it? What its status is. So these are some of the reasons why we needed an umbrella law on mediation. Does the law meet these needs? Yes and no. You find that it has not taken the Singapore Convention as a part of the law. It does speak about international mediations, but it doesn't address the Singapore Convention. The argument of the government before the committee was that it wasn't yet time for them to implement it, and they wanted to see how other countries implemented it. To me, that doesn't seem to make sense, because Singapore has implemented it and has a law on international mediation and settlement agreements. So if we want to be a place where people will come, to resolve their disputes, we should have taken a lead in that. The second is that we've in fact taken a step back when we say that agreements to mediate, that is, when parties entering into a relationship or decide that we will resolve the dispute through mediation. Though the bill devotes two sections to it, there is nothing there that says that an agreement to mediate will be enforced. The other problem is the Mediation Council and the extent of state control over mediation. The Mediation Council is completely populated by the government, and there's extensive government control. The fourth is the regimen that the bill puts mediation into, by requiring that a settlement agreement will be in writing, by saying that you will register settlement agreements. It does say it is optional, but why this should be registered, access by the government to settlement agreements again is a problem. It deals with community mediation, but in a very, very ham-handed way. So a lot of problems with the bill.
Thanks, Chitra. Ekta, before I come to you, I just want to point out, for those of us who are not familiar with the bill, the actual preamble specifically says to promote and facilitate mediation, especially institutional mediation for resolution of disputes, commercial or otherwise. So there's a focus on institutional mediation, a focus on commercial mediation, enforce mediated settlement agreements, and that's something Chitra just touched upon. Do we really need the Act to enforce it? Provide for registration of mediators to encourage community mediation and to make online mediation acceptable. So, of course, it also talks about cost-effective process. So just from the preamble, these seem to be highlighted points that the legislature wants to put across. So your thoughts, you can choose to pick up these or otherwise just initial overview of the bill. Thank you.
Thanks so much. In fact, Chitra raised a very interesting point. We needed a mediation bill to sort of streamline things. And while we have a bill, I think it's lip service. So when we're talking about consolidated, that we're looking at a comprehensive law, it's still left out some legislations and saying that mediation will be covered under those legislations, second schedule. And importantly, if you look at the Industrial Disputes Act or the Labor Code or even the POSH Act, the processes which this bill through its rule could have laid out would not be followed in those. And if you've seen even in the POSH Act, there is nothing which says how conciliation should take place. It's left at the whims and fancies of the IC, and ICs typically don't understand, what is required as part of the conciliation. So I think that, when we're looking at bringing a law which is supposed to be a comprehensive law, I think we could have gone more into saying that how can we make it more comprehensive? Also in terms of, confidentiality, again, I say no lip service. So we've touched upon confidentiality. We've said, yes, we need to make everything confidential, but the consequences of not maintaining the confidentiality, the consequences are not anywhere highlighted in the bill as well. We spoke about pre-litigation mediation. The committee came back with suggestions saying that, yes, okay, make it optional, but have a roadmap for implementing it in phases. So while it has been made optional, but the entire roadmap for making it optional, of implementing in phases is missing in the bill itself. So, it would have been nice to see an enabling provision saying that the government could notify, such other disputes which will be subject to pre-litigation mediation, as may be prescribed. But we've not seen that. When it comes to, even when disputes which are not fit for mediation, while, we understand that, they wanted to have a larger cap, but in terms of, it's only criminal cases, it's only limited to compoundable matters that can be referred for mediation. Again, enabling provisions where the courts have the power to refer any matters that they deem fit for mediation, which could even be form part of part 1, or schedule 1, it doesn't matter. But if the courts have that power, you could have enabled and brought more cases which could have been mediated. Today, they're out of, out of the entire scope of the bill itself. Who can, who can mediate and where? I think we'll see a lot of questions coming in terms of interpretation of, how do we look at territoriality, which law does come in, where do I enforce it? I think there's a lot of ambiguity in that. And it's a good thing they've given 5 years to sort of clarify, and resolve any clarifications and doubts. It's gone up from 3 years in the 21 bill to 5 years. So we have a long period of time to sort of probably get the bill to address some of the concerns that have been raised from time to time. Issues on, in terms of the parties don't agree to a mediator. So, while, it's again open-ended, which mediation service provider do I go to? The good thing is there's a lot of recognition given to mediation service providers and even mediation institutions, but we'll have to see, how the rules look at it, and, how they enable the process through the mediation service providers and the mediation institutes.
Thanks, Ekta. I just want to tell the audience that there is a whole schedule under Section 6, which talks about disputes or matters not fit for mediation. And there's a whole thing that's close to 13 entries, including the last one, which says any other subject matter of dispute which may be notified by the central government. So interesting that that can be notified, and the central government can decide something cannot be mediated by putting into this. And of course, those of us who've been part of mediations know for a fact that a lot of mediations don't happen with the government for various reasons, although the Act contemplates right now possible commercial disputes with mediation. So Chitra, coming back to you, the nature of application of this law is worded that this Act shall apply where mediation is conducted in India only. So, I mean, it leaves out mediations that have not been conducted in India. And therefore, again, going back to the Singapore Convention, that could have been stronger. Also, it still talks about international mediation. So it says, if the mediation is conducted in India and if it is an international mediation. And the definition of international mediation means, if one of the parties is not Indian, or a body corporate who has a business outside India, or a place of business outside India. So I just wanted to get your thoughts here on what really have we missed the boat in terms of the Singapore Convention. 50 odd countries have signed it, including India. 6 countries have ratified it. The view of the government seems to be none of the significant countries or big countries, whatever that might be, have not signed, not ratified the Singapore Convention. But in this context of international mediation, enforcement, Singapore Convention, what more could the Act have provided for?
To start with, the Act should have incorporated the Singapore Convention. I think that was necessary. Talk about improving our, our state of affairs in resolving disputes. We know that we are not the preferred destination for dispute resolution. We should have incorporated the Singapore Convention because that gives a comprehensive approach to enforcement of mediated settlement agreements in commercial disputes, and therefore it is a narrow area of disputes. What we've done, in fact, so apart from not incorporating the Singapore Convention, what we've done is worse. You have 3, for instance, and this is, the shabbiness in the drafting is so evident. You have 3 definitions of commercial mediation, 3 definitions of commercial. One, the definition under the Commercial Courts Act. The second, you have a definition of commercial, which is international commercial mediation. I'm sorry, there are 2 definitions. The second is commercial under the international commercial mediation, which defines commercial as anything that any relationship that could arise whether out of contract or otherwise, which is extremely wide. And the third is the definition of commercial in the Singapore Convention, so which defines commercial as a relationship or a commercial dispute where both parties enter into that relationship with a commercial purpose. So it's narrower in definition than commercial disputes under the Commercial Courts Act. Now, if you're saying that you want to implement the Singapore Convention at a later date, what you've done in the Act by defining commercial for international commercial disputes in such a broad way is that when you want to bring in the Singapore Convention, you've already created, jurisprudence, you've created a way of dealing with international commercial mediations in a certain way. You've provided grounds for enforcement of settlement agreements arising out of international commercial mediations that are at great variance with what is there in the Singapore Convention. The grounds here are corruption, fraud, which are the basis on which, and impersonation, which are the basis on which you will evaluate a settlement agreement before you, if it is challenged. So the two go in totally different directions. The Singapore Convention has grounds that cover diversity of parties, that cover situations where the agreements would be void, situations where the agreements would be voidable. It deals with situations of public policy may have depending on their culture, their politics, their society, and the values that they hold dear. And challenge to a settlement of misconduct. Now, this bill has taken a completely different direction. So when you are going to look at, when you think the time is right for you to implement the Singapore Convention, it's a great deal of dismantling that is required, that will need to be done in this law, as well as the churn that transition is going to cause. Sadly, it's going to set us back so much in confusion and uncertainty.
Thanks, Chitra. Ikta, I'm going to go to you now and ask you some of the points that Chitra just mentioned, right? And if you look at the Arbitration Act also, as a comparison, there are, of course, challenges range from public policy, from other things, whereas here, and that seems to be the biggest challenge ground, whereas a lot could have brought in from the Singapore Convention, but somehow we've not brought it here. I just want you to talk about a little bit more in the context of pre-litigation mediation. Do you think more could have been done there? Can you impose consent by making pre-litigation mandatory, or are we okay where we are? Just in terms of what the language actually says, it says that whether any mediation agreement exists or not, parties before filing any suit or proceedings of civil or commercial nature in any court may voluntarily and with mutual consent take steps to settle the disputes by pre-litigation mediation. Then, of course, there's a reference to 12A of the Commercial Courts Act. So, I mean, I'm going to take a contrary view here and say it really doesn't add anything. It just says may voluntarily with mutual consent. So, then you can sort of say, why do you need a mediation bill at all? You could have gone ahead and enforced it in the conciliation process under the Arbitration and Conciliation Act, other than, of course, the larger issue of raising awareness and saying, hey, we actually have an act on mediation.
So I think, see, when we look at pre-litigation mediation, I think, and if you look at the purpose of the bill, one is, it's legitimizing and giving greater emphasis on institutional mediation. And that is something that we don't have on ground today. But in terms of a value add from where we are today, when it comes to pre-litigation mediation and what the bill brings in, there's nothing. You have Section 89 where the courts, the court has empowered to refer matters for mediation. You have, the ADR rules, which are there by various high courts, and those again remain untouched. So, the courts can refer parties to mediation. Parties even today can go to court and saying, I want to try pre-litigation mediation, and go into the court annex system as well. It's just that today we didn't have, while Arbitration Conciliation Act was there when it came to private mediation, but we didn't have recognition of mediation service providers for institutions. So that's the only real value that, in my mind, the bill is sort of bringing on the table. But when it comes to pre-litigation mediation, and I know that there are lots of, depending on which hat you wear, there are people who say that, mediation is voluntarily, you can't force it on parties. But if you look at the pre-litigation mediation, and if you look at the bill, it talked about the earlier version of the bill, it only talked about 2 sessions. Could it be that it's more of a sensitization that, parties come, see what it is, experience it, have a conversation, and then decide whether they really want to continue with it or not? So that was also to build awareness. That was one way to look at it. But by deleting it completely and not providing any enabling provisions, if the government wants to introduce pre-litigation mediation for other kinds of disputes in the future, there's no enabling provision in the bill today. So how will they go about, bringing that there? Because if you look at the committee, they also mentioned that they can introduce it phase-wise. Today we are doing 12A. Let's see how 12A goes. And we've seen, 12A has been helpful in some states, but in some states it's not really taken off. How do we improve the element of pre-litigation mediation there and then take it to other forms of disputes?
Thanks, Ekta. So I think there's a question here, and it's sort of connecting to what we're just talking about. So I'm going to take that up. It's a question from Vinita Sahai. So her point is that, under 12A of pre-litigation mediation, the mediation period is a maximum of 3 months, extendable to 2 months, consented, of course, by parties. The mediation bill says that it's 120 days, extendable to another 120 days on request of parties. So what is the final understanding of the mediation period in commercial court or on the commercial matters, especially if it's a 12A pre-litigation mediation? I personally feel it's a very, very long time for a mediation. And if you really want to extend it, of course, Chitra, feel free to jump in if you have any thoughts. Ekta?
So actually, if you look at it, the 9th schedule, remedies that, because the Commercial Courts Act is being amended in the 9th schedule. And I will read it out. Things, it shall be complete the process again. It's brought in 120 days and 60 days as well. So I think some of these things will either get clarified, as part of the mediation bill. Otherwise, we have 5 years to sort of iron out any inconsistencies.
Chitra, any thoughts on the timelines there on 12A?
12A3, there's an amendment in the 9th schedule to the mediation bill, which amends the Commercial Courts Act itself.
Okay.
Sorry, I just wanted to add something on pre-litigation mediation.
Yeah.
This bill actually takes us a few steps back because, like I said, parties can agree to mediate if disputes arise, right? They can put it in their agreements. But what this bill does is to say that even if you put it in your agreement that you would mediate if a dispute were to arise, in order for you to, when the dispute arises, in order for you to have recourse to mediation, both parties must agree. Which then, makes one ask the question, why put something in an agreement at all, and why is this bill actually dealing with it in sections 4 and 5 in such an elaborate manner when you don't mean to give any effect to it? And this in the context of countries like Singapore and the United Kingdom taking steps through judgments of courts to enforce these agreements, to direct that there will be specific performance of agreements to mediate. We are going a few steps back and saying, unless both parties consent again, this agreement to mediate will not be given effect.
Can I just like to add something to what Chitra says, and this probably adds to how it'll get interpreted. It'll be very interesting. So when there is an existing agreement, and when do you look at commencement of mediation, and then taking to section 14, it says when the other party receives the notice for commencement. So while you're talking about an agreement in writing, then we're talking about how the mediators are to be appointed. But the commencement is when I receive notice in writing, if there's an existing agreement. So, and we talked about it being voluntary as well. So it'll be good to see how some of these inconsistencies of the bill actually sort of play out. going forward.
Thanks, Ekta. Chitra, I'm going to come back to the Mediation Council, especially somebody whose practice is not only mediation, but also a significant part of the work that I do is also arbitration. So the concern here is what is this entity going to do, and how much is it going to invade, and or what kind of role will the mediation council play, and how will it come to be? So two things that are really of concern for me is, one of the things that the mediation council shall do is call for any information or record of mediation institutes and mediation service providers, i.e., so if you and I mediate something, we then have to be ready to share that with the mediation council, because they shall call for it, and presumably we must give it. Second is maintain an electronic depository of mediated settlement agreements made in India and for such other records related to. Now, mediation is not really precedent setting as it like a judgment or like an arbitration award, right? You're not going to use it as a position in law. Mediation is creative, it can go in different manners. So the need for a repository of mediated settlements, again, how much of that is breach of confidentiality, how much can one redact, how much does one have to disclose? Of course, the rules may further clarify this, but these are things that I immediately thought would be of concern to me. So thoughts on that, or anything else on the Mediation Council?
Yes, so the Mediation Council, as is the case for any professional body, should be a self-governing organization. We deserve that, and we need it. Now, for the government to pack the Mediation Council with their nominees entirely, you have officers from the government in it. This is not our professional organization. We deserve to have an organization where we elect our persons as the governing body, and this body then gets inputs from us, as well as having persons who are of the mediation body, democratically elected, who are then making rules, making regulations in advocacy, in certifying mediators, in registering mediators. So that's point number one, and that's been taken away from us. The second is that everything that this mediation council does will still need to go to the government, and the government can prescribe what needs to go in and doesn't go into mediation. And I think this is in, if I'm not mistaken, section 53. I think I think I've got the section wrong. But
38 talks about the council and its role.
I think this is in, just give me a minute, information going to the council, going to the government. All policies will be sort of determined by the government. This is in, I'm sorry, I'm taking time.
No, while you do that, there's a question exactly on that from Jonathan, who we all know is part of the community. So I think the question is, how does the mediation community in India, for those who've been involved, take responsibility for the consequences of this legislation, particularly in terms of mediation council, so that healthy leadership and representation continues to play a role? Sort of a broad question, but what can we do now that this is what we have to play with?
Certainly, we will need to consult and engage with the government and see if this can be changed. I mean, it does seem a little late in the day, but to engage with the government to see how this can be changed. And the alternative is that we form a federation of ourselves. One voice, what is happening in mediation, how things need to be in mediation as a counterpoint to the mediation council. These are two ways I see in which we can respond. In terms of confidentiality and information, you see that every settlement agreement, you have an option to register it, and that's when it goes to the repository. But you are required, if it is institutional mediation, to provide a copy to the mediation service provider. And once you provide the copy to the mediation service provider, it's in their records, and the government and the mediation council are able to ask for this information. There is nothing that I'm able to see. One needs to look at the rules and the regulations, but nothing that I'm able to see in the act that forbears the government in the kind of information it can pull up from the mediation service providers.
Thanks, Chitra. I think now we'll officially begin to take questions since we're at 5:30 or so. Veena has two questions. One is, if both parties consent to mediation, is there scope for any interim orders to safeguard? Veena, in my experience as counsel who encourage mediation, we would go get that interim order first, because the nature of the interim order presumably would be of some urgency, and we really can't wait to figure out if the other side will consent to it. But I'll let the panelists take a shot at it. The other question, which is connected from Veena, is she's seen partition suits sent to Lok Adalats, and divorce matters are sent for compulsory mediation. Are there any changes to this larger system of Lok Adalat and compulsory mediation where court sends off matters? How would that play out with the new Mediation Act?
I'll take Veena's first question first, if that's okay.
Yeah.
In terms of interim orders, I think we've seen the problems that the Commercial Courts Act has caused, because the language in Section 12A says that if you don't contemplate any interim relief, you can file a case. And that has caused a lot of issues, because the Madras High Court has taken a view that time is the only sort of reckoner. And if you've delayed approaching the court, then it doesn't contemplate an urgent interim order, and therefore you cannot file a case in court without attempting mediation. Now, the mediation bill, I think, by not mandating pre-litigation mediation, allows for parties, like Purnima said, to be able to file their suit or proceedings, get their interim orders, and then go on for mediation. Likewise, there is a provision where the court refers parties to mediation, where it says that if there are any interim orders to be given, the court will then dispose of that application, either by granting or rejecting the interim relief, and then refer the parties to mediation.
Ekta, do you want to take anything else over there? Thoughts?
I think Chitra covered that, but coming to the Lok Adalat, in fact, the bill clearly says that provisions of the Lok Adalat, this bill does not apply to it, and therefore we'll have. So I think that the parallel of what the Lok Adalat is doing today will continue.
Thanks, Ekta. One more question from a student is, is the future bright in mediation post the bill, or would it just be an additional feather in a lawyer's hat? Ekta?
This is an interesting one, because I think we've had mediation in the country now for over 25 years, and we're seeing it grow. And I'm actually hoping that this just doesn't become a feather in a cap, and mediation as a standalone practice for practitioners does pick up. But I think in the immediate future, that may not be so. But I think over a couple of years, you could look at pursuing a career in mediation.
Thanks, Ekta. So while we wait for other questions to come in, Chitra, for you, the challenge to a mediated settlement agreement, and the language of the Act is, a mediated settlement agreement may be challenged only on all or any of the following grounds: fraud, corruption, impersonation, where the mediation was conducted in disputes or matters not fit for mediation under Section 6. Contrast that with the Arbitration Act, where a challenge can be if a party was under some incapacity, the arbitration agreement is not valid under the law. A party making the application was not given proper notice of the appointment of the arbitrator or the arbitral proceedings. Basically, natural justice has not been taken care of. Also, public policy and such other things. The Singapore Convention, of course, talks about other things. So, why only fraud, corruption, impersonation? Impersonation, I think, sits out a bit oddly. What is the context here? And if you want to give your thoughts on it. You're on mute, Chitra.
Sorry, I'm sorry about the disruption. The grounds for enforcement or challenge of the mediated settlement agreement are grossly inadequate. I don't know what impersonation means in this day and age when all of us have electronic, biometric identities. Fraud, of course, is important. The third one, which is corruption, also, I don't know what it means, how wide, how deep, how vague, how specific. It's unclear what that ground is. Remember that the Mediation Bill deals with civil and commercial disputes, which means there are a whole range of disputes that could come up in this context. What about best interests of the child? What about grounds that are voidable? Grounds of undue influence, grounds of duress, grounds of coercion. It's possible that this could happen in a mediation. The mediation settlement agreement straddles two sort of elements. The first is the element of the agreement, and the second is the element of resolution of a dispute. And I think these two aspects need to be taken into account when you're looking at when could there be problems in the settlement agreement? When can we allow a person to question an agreement that they have entered into? Neither is covered. You also find that it says there is a section elsewhere which says that an agreement that is void, the settlement agreement that is void will not be a valid settlement agreement. What does one do? Are you supposed to say, well, my agreement is void, I'm not going to implement it, I'm not going to challenge it, and that's the end of it? So you're in a sort of a, not, neither here nor there in terms of where the settlement agreement is insofar as the parties are concerned. So it's disparate, it's inadequate, and it doesn't see the settlement agreements for what they can be. For instance, the interests of a child, that could be part of the settlement agreement. And it should be possible for a person to challenge the settlement agreement by saying that, look, it doesn't adequately or properly address the interests of a child if a child's interest is involved in the settlement agreement.
Thanks, Chitra. There's one more question for you. Could you elaborate on the standards that would be set up for mediation institutions and mediators? Radhika Shapurji has asked that question. Of course, my concern is how much should there be a standard and how much should it be left open for consumers or stakeholders of mediation to choose who they want, irrespective of accreditation, irrespective of measuring up to a certain thing. You may have an excellent mediator who somehow didn't get accredited, but who you parties would trust and say that this is the person would want to mediate their dispute. Thoughts on that? Thank you.
Let me say something good about the bill now. It does allow for parallel tracks of mediation, which is that you are still free to choose your own mediator. The mediator doesn't have to be registered with the council. The mediator doesn't. And for a mediation service provider, in the way I've understood the bill, they don't have to take only registered mediators on their panel. It could be anyone. It could be someone who has experience in a certain area and is able to understand the issues that generally come up in disputes and be able to help parties resolve their disputes. So these parallel tracks are, of course, welcome because, if a person, like you said, Purnima, wants to choose a particular mediator who is not registered, who is not trained, well, they must have the autonomy to do so. In terms of standards for mediation service providers and mediation institutions or mediation service providers, you said, I think the standard should focus on certain elements in the mediation process, namely confidentiality, their use of online processes, accountability in terms of, persons they have on the panel, the ability of parties to be able to complain in case there are any issues with either the mediator or the mediation, the service provider. So these are, I think, elemental standards that need to be there, including ensuring that parties have autonomy and self-determination in how they resolve their dispute, how they choose their mediator, and finally, their autonomy in deciding that they don't want to give the settlement agreement to anyone or to put it in writing.
Thanks, Chitra. Ekta, do you have any thoughts on that? Or there's another question which talks about, how does the act or the bill, as it were now, make provisions for a mediation agreement to be enforceable? There are specific provisions in the act. Do you want to touch that?
So the act, in fact, if you look at it, I'd bring about one is in cases of mediations other than community mediations, because for community mediations, the bill actually says that they cannot be enforceable. But when it comes to mediations other than community mediations, it says that it can be enforced as if it was a judgment or a decree. So the bill clearly provides for any mediated settlement agreement under the bill, once it's implemented, will be enforceable as a judgment or a decree.
Okay, a last few questions, and then I'll look for closing comments. There are some general questions on what is the training that's required for mediators? Is the 40 hours sufficient, or can there be more? And can advocates act as mediators? Is there a career there that one can do, especially in light of the new bars that have been set by the act? So thoughts on that, and then I'll also like you to have some concluding remarks while you address those, and then we'll close shortly unless there are some burning questions that come up. Ekta, first, please.
So one is, if you look at, so the question was actually 40 hours to my mind is not enough. And I think 40 hours just gives you an introduction. And there is just so much depth of learning that comes over a period of time. So, and I think when we're looking at the rules, I think that's where we'll probably get some sense of how we're looking at training in India, whether it's, traditionally it's been 40 hours, but you have countries who do 60 hours, you have countries that do 20 hours as well. So what would be our benchmark? I think time will tell, but I don't think 40 hours is enough. And I think we need more. I don't know, Chitra, do you have similar views or they're different? Because everybody has various views on how much training is enough.
There's more than the 40 hour, I think, we need to have continuous training, continuous education. And, that to me is far more important than whether it's 30 or 40 hours. I don't think that's indicative of anything.
Yeah, it's difficult to compute time and training together, right? I mean, you could have 10 hours of fantastic training and hundreds of hours of mediocre training. So it also depends on the quality of training that you get. I think that's really it. There's one question again, Ekta, for you. Commercial dispute cases where claim computation is in question, advocates would emphasize parties to go for mediation, seeing what the mediation bill stands today. In very specific, commercial disputes, claim computation.
I think you could go even for where the computation's in question. Mediation, since it's the way the process of mediation is, it's very flexible. So parties can still get in experts to sort of determine how that computation should be or could be, and then work around finding the solution that works for both of them in terms of the computation as well.
Thank you. I'm going to end there. We're above our 45 minutes. Thank you so much for joining in. Feel free to write to us if you have any further questions. It's been wonderful to have such an engaged audience, and we hope that the bill will actually make a difference, and I hope that the mediation community continues to stay engaged as it has been to make sure that we move the needle forward. Chitra, I hope you get home soon. Thank you for joining in. not easy to be in a car and in the middle of rain. Ekta, of course, thank you for joining in. Thanks, everybody. We'll end now. Thank you.
Thank you so much. Thanks. Bye.
Bye bye.
Thanks. Bye.